There we go. Okay, great. Right. Good afternoon. Welcome. As I think most of you know, my name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. And we hold these meetings every month for folks who are involved in post-conviction litigation and investigations through a grant from the Bureau of Justice Administration and the Office of Justice Programs to be able to provide training and background information for people who are doing this kind of work all around the country. So this month, we are doing a little bit of a self-pat on the back, I think, or self-promotion because of the work that we do. In addition to this work that we do with working on providing training, information, and expertise to folks around the country, we also, of course, are evaluating programs for the Bureau of Justice Administration as part of our TTA experience. And our evaluation manager, Kia Hayes, who's going to be taking over in just a minute, has been leading that effort for the past several months. Many of you may have been participating in that, and of course, we thank you very much. But we're at the point now where we can share some preliminary findings with you. And of course, I need to point out the co-managers of that team are Taylor Migliori, as well as Professor Charles Loeffler, who's with the University of Pennsylvania Criminology Department. And they're going to be joined this afternoon by some folks from the Michigan Attorney General's Office and the Cooley Michigan Innocence Clinic, Innocence Project, who also took part in the evaluation and to talk about their experiences and what we've been learning about these cooperative programs between conviction integrity units and innocence organizations. So remind everybody, of course, as always, we encourage you to have your cameras off if you are so comfortable, so that we're speaking to actual faces. Any questions that you have, please feel free to put them in the chat and we'll be sure to address them as quickly as we can. And I think with that, I hand off to Kia. Thank you, Kia.
Great. Thank you so much, Marissa. Let me just share my screen. Excellent, I did it. Well, thank you so much again. Welcome everyone. Welcome back and Happy New Year. So as Marissa said, we're going to tell you about our evaluation project that we have been bugging you about for the past several months. And thank you so much for carving time out of your already crammed calendars to talk to us, answer our many questions about your projects and how they went and all the twists and turns you encountered along the way. We received a ton of valuable information and it gave us a great sense of the landscape of these projects and we got some emerging themes that we'll be sharing with you today. Me and Taylor and Charles are going to share some of our preliminary findings with you, and then we'll take your questions on that, and then we will welcome Tracy and Ann from the Cooley Innocence Project, and then Robin and Lori from the Michigan Attorney General's Office, CIU. But before we get started, we are going to do a hopefully fun poll. So if everyone can, either on your computers or on your phone, go to this website, pollev.com. I guess that's a / Kia Hayes 116. This works. So this is just a little icebreaker. In one word, great, it's working. Tell us how things are going for you today. I will share my somewhat hectic morning trying to get my 4-year-old to daycare. We encountered a lot of big feelings, and I had driven her to daycare, which is unusual. And as a result of all the big feelings, I was so frazzled, I walked home forgetting that I had driven, and then had to, like an hour later, I was like, where's the car? And then, it's still at school. So that's where I am. Great. Everyone seems to be doing pretty good, better than me. That's good.
So Kia, I think you need to advance the screen one to get the results in if you want.
Oh,
sorry.
I don't know if it's still, so the responses aren't showing up?
They are not just yet.
No, Taylor, are you able to
I've
come up?
got something going. She's got
Yeah, I
something,
think you can just drag
I'm
the,
in a training, yeah.
but feel free to not want to do anything.
you can just drag the actual Poll Everywhere tab over to your screen, and it should show.
It's gonna help. Sorry about this. We tested it yesterday and thought it was going so well. Taylor, are you coming?
Yes.
Yep. Oh.
There we go. Okay.
Success.
Now. Good.
Is it there?
Beautiful.
Yep, showing up great.
Okay.
Okay.
Thank you so much.
Of course.
Now we can go on to the next one. It's complicated is kind of just a catch-all if it's not a clear yes or no. And we are getting some of those, so maybe for folks who answered it's complicated, feel free to tell us in the chat what that means. If you haven't worked in collaboration, are you interested in doing one? If you are interested, if you could tell us in one word, or if multiple, do an underscore in between why you are interested. Seeing results, exonerations, different points of view, successes, justice. A lot of things are surrounding exoneration results, justice, vacate. Thank you. And then finally, for folks who are not interested, it seemed like everyone was interested, but what barriers do you perceive would prevent you from working collaboratively? We're seeing trust, delay, mistrust, resources, politics, lack of resources. That tracks with some of the things we experienced as well in talking to you. So, great. Thank you so much. So now we will move on. Second, we'll go back to the PowerPoint. Okay, so moving on. So for those who are not aware, as Marissa said earlier, so we are BJA technical assistance and training providers. That's just a fancy way of saying that our job is to help you be successful in your conviction review projects, in your goals to evaluate convictions, identify wrongful convictions, and vacate those wrongful convictions. We just have this up because every time we talk to people, a lot of times we hear that people aren't really fully familiar with all of the things that we do to that end. So we wanted to share that again. So we regularly meet with newly formed CIUs getting off the ground, new elected prosecutors who want to create CIUs, establish CIUs. We have a ton of resources on our website, convictionreview.net. Sorry, I'll speak up a little louder. I hope this is better for people to hear me. We post a ton of resources on our website, which is convictionreview.net. You can find model policies, templates for cooperative agreements, checklists for practitioners. We have a lot of information from Healing Justice, which is an incredible organization that works to support survivors. And we also have much more there. So we also post all of the videos from these monthly webinars on that website. So I encourage you to go and check it out. And so for all of you probably already know this, I'll go quickly. CIUs, still relatively new. There weren't any in 2000. As of 2016, there were 27, and now they're around 122. This was from a couple months ago, so forgive me, Marissa, if there's one or two that's popped up since then. More than 50 have been created in the last 5 years. The rise of CIUs has created a lot of new challenges for innocence orgs that already existed in those jurisdictions, in terms of determining whether to advise clients on whether they should apply to those new CIUs, and whether and how to share information with them. They've also created a lot of opportunity for collaboration. And so, because CIUs operate outside of the traditional adversarial system, working with them can provide a lot of hope for wrongly convicted prisoners who would otherwise have no avenue for relief. CIUs can also provide access to records more quickly. It can make work more efficient, move faster for practitioners and for prisoners. But they also provide a lot of challenges. And so that's one of the things that we wanted to look at in our evaluation is, what are those challenges that arrive when traditional adversaries work together? What are the emerging themes that are sort of popping up that a lot of these collaborations are experiencing? What are the strategies for overcoming those pitfalls? And so that's what we want to look at. That's what we wanted to look at in our evaluation. That's what we'll be sharing with you today. And so that was the objectives of our project. So we've interviewed 28 CIU and innocence orgs. So that's 14 grant projects. It's the first qualitative research project of its kind. And I think next we will turn to Taylor to talk a little bit more about the methodology.
Yeah, sure. All right, thank you, Kia. Let me just go ahead and share my slides as well. Oops, so sorry. There we go. All right, hopefully you can all hear me as well. But thank you, Kia, again. So getting into kind of the who, what, where, when, and how, for lack of better words, of kind of what we did, the methodology. So like Kia mentioned, we pulled all of our data from a pool of grantees and subgrantees. These all received BJA grants, whether in fiscal year 2018, 2019, or 2020. And these were the first grants of their kind to support this kind of collaborative work between CIUs and wrongful conviction review entities. So we really wanted to see if we could find any patterns, any themes that emerged throughout these collaborations since they were so new and so unique. So that being said, we did qualitative interviews. So these consisted of 60 to 90 minutes per grantee or subgrantee. There were a bunch of questions that we asked in an array of categories. But basically, we wanted to know the individual career paths of the people who were being interviewed, how they sort of got into the work, how they got to their office, how they got to getting into this collaboration in the first place, how the project came about, whether it was through, somebody's platform that they were running, whether it was a new office that they kind of wanted to implement, whether it was something that, the office had been there for a while, but they needed a new avenue for funding. We kind of wanted to see how that came about. And then we were also obviously interested in the development of that project over time. So how it started may not be how it ended, as there were bumps along the way, if there were successes along the way. We really wanted to get those broader reflections about the challenges and the successes that each grantee and subgrantee faced. And I think it's important that we note that we did these interviews separately, and while there was overlap in the questions themselves, we did not use information gleaned in the grantees interview to inform our questions for the subgrantees interview, if that makes sense. So everything was kept very separate, just to keep it clean and sort of keep the integrity of our questions intact. And then here's a little graphical map kind of showing the offices that we interviewed. So FY 2018 is all in blue, FY 2019 is all in red, and then FY 2020 is in green. As you can see, there were some doubles. So particularly in Michigan, 2 of the grantees actually received the grant in 2 separate years. So they were actually a subgrantee or a grantee in 2 separate years. So that's why there's a red circle around the blue circle. And then similarly in kind of like the Maryland area, and then some other doubles down here in Florida, and also in Kansas City, Missouri, and Kansas. So this is just kind of a graphical representation, if you guys were interested, who was in our project. And then here's some examples of the questions that we actually asked. So it was a little bit more organic in the actual interview process, but we did try to stick to kind of these major themes and major questions as much as we could. So like I said, kind of their path, their career path into the work, how it came about, what the overall expectations were, what they kind of wanted to achieve within that project, and then obviously the level of enthusiasm both at the individual level as well as the wider office level, because those can differ. So we wanted to see if there were any changes there, particularly whether the roles of each office were clearly defined. We'll talk about that a little bit later with our guests. And then also how they handled any tensions that arose, because inevitably there's going to be something that you disagree on, how they felt voicing those concerns with the other office. And then finally, we kind of wanted a broad look back, how it was successful, how it was challenging, and then for BJA and for us also, kind of what advice they would give to other people who are considering doing a collaboration of this sort. So kind of a more particular breakdown. We started with the interview, so the qualitative interview with all those questions. We recorded it and we downloaded all the audio files, and then we actually transcribed them all. So we used a software called Trint. It's AI powered, basically just to get kind of the broad transcript itself, and then obviously we had a member of our team go in and kind of clean it up, because AI doesn't exactly get everything. So we went in and cleaned it up. We also redacted everything. This was for the privacy and obviously the security of the people that we interviewed. All identifiers were taken out, so any names that were brought up, any geography, any locations, any case details, everything was scrubbed. So basically nothing is identifiable at this point. And then this is kind of where we're going to now. Obviously these are all preliminary results, but we wanted to share kind of our major themes that we were finding with you guys. But our next step is to kind of thematically code and evaluate any shared experiences and lessons learned across the sites. But with that, I'm actually going to toss it over to Charles, who is doing all of the thematic coding and kind of the larger themes to kind of go into his slides about what we found.
Great. Thank you, Taylor, and nice to see so many folks on this webinar. So I'm going to talk a little bit about 3 emerging themes. There are definitely more, but these sort of give you a chance to see sort of the insights that we can glean from the shared experience that many of you on the call have been so generous to provide us, and also some of the interesting complexity involved in doing this work. And so the 3 themes we're going to focus on today are commitments, capability, and constraints. So in terms of commitments, which is this first emerging theme that I'll illustrate with a couple of quotes. At a broad level, IO partners, innocence organization partners, and CIU or CRU partners in these collaborative conviction integrity grants are all broadly committed to the idea of identifying and redressing wrongful convictions, particularly involving those people who are imprisoned. And this is sort of the broad shared commitment that allows these collaborations to take place. And actually, Taylor, if you wouldn't mind advancing one slide. However, there is an interesting tension that exists. So when we think about innocence organizations, these are organizations that have an organizational imperative to free the innocent. And that's a longstanding organizational commitment for innocence organizations. But one of the interesting complexities that collaboration creates is that that's not all of the work of collaborative conviction integrity work. And so what you see here is in sort of the second bullet point is one of the things that happens and that surprise a number of the innocence organizations working in these collaborations is what happens when you actually find inculpatory rather than exculpatory information. So as you can tell from this quote, one organization participant said, "I was really surprised by how many inculpatory results we got back. I couldn't believe how many people were hollering and saying, yes, 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 test. Like we had 2 guys who originally their profile was not confirmed, and they obviously consented to testing. And not only did we confirm that, yes, they were in fact the true perpetrator, they got a CODIS hit on extraneous activity because of that. So I'm just like, people are crazy. So this is something that the innocence organizations in a number of collaborations were not anticipating they would encounter, and yet they did. And what's key in sort of making sense of this, sort of single bottom line for innocence organizations and the complexity of that for a collaboration is if you look at this next quote, set of quotes from CIU and CRUs, we can start to see how that same event meant something different for them. So if you see this first quote, I think it's a successful review when we find that we have confidence in the conviction and no actions need to be taken. That was an attorney with oversight responsibilities at a CIU, CRU. And another CRU oversight supervising attorney said, quote, "We're not the exoneration unit, we're the conviction review unit, we're quality control." And so while you can have 2 organizational partners that share one broad commitment, the actual work of reviewing cases can create these organizational tensions where the CRU can view a confirmation of guilt as something that is organizationally useful, and the innocence organization can view that as just sort of orthogonal to their organizational mission. And you can even see this challenge work out at different levels of the organization, where individuals who are frontline attorneys in CRUs can view this as confusing when confirmation of guilt is found, whereas higher level managers within CIUs can view this as something that is good for the organization, even if it is confusing for the individuals who are who are reviewing these cases and investigating these cases. So we have this sort of interesting tension between single bottom lines and double bottom lines. Taylor, if you could advance to the next slide. But another, sort of really shared understanding that we saw was in the recognition that CIUs and CRUs often had complementary capabilities. And this really was the foundation upon which the interest in collaborating came from and was built upon. I illustrate sort of the way in which both innocence organizations and CRUs identified the sort of organizational capabilities of innocence organizations. But trust me, and you'll see in the report that we generate, there was broad shared understanding that whether we're talking about protocols for reviewing cases, whether we're talking about just having staff, there was a broad recognition that innocence organizations had a number of capabilities that were enormously important for the shared mission of reviewing cases and freeing the innocent. Now, if you look at the capabilities of CIUs and CRUs, I put up a number of examples here, quotes, of how there was a recognition that there were just authorities that and access that CRUs, CIUs had. Interestingly, it wasn't always about just sort of getting evidence to test, although that did come out in a number of these collaborations. But there was this strong emerging theme of sort of authorities, or what we're calling authorities. So if you see this first quote, quote, for post-conviction, most if not all jurisdictions have very high bars for what evidence you're allowed to present in a post-conviction motion, and the rules are all geared toward the finality of the conviction. So they're very onerous and very, very difficult to overcome. The whole purpose of the CIU is to remove those onerous requirements to get to the truth. And so there is a recognition, at least in this and many other organizations, that having a new process and having a way in which information that could be presented that wasn't just under the classic sort of court relief-based statute relief was something that was very beneficial to identifying wrongful convictions. And you can see this come out again in this somewhat longer second quote. Quote, what we are doing is something very rare in our judicial system, which is trying to, truth-seeking, actual factual truth-seeking. But because of the way our system is structured, somebody needs to, quote unquote, oppose, right? There's always got to be two parties. So is it going to be the local prosecutor's office who has designated the opposition? So legally speaking, we write a brief saying, we believe this person's innocent, and here's our evidence. And they're ordered by statute to write an opposing brief saying, here's why we don't think this person is innocent. Obviously, if we can get them on our side so that instead of writing, here's why you're wrong, and here's why all your evidence is bogus, and here's why your witnesses shouldn't be believed, if instead they're saying, we completely agree, we have met with the IO and we have reviewed all their evidence, and we think all their witnesses are credible. We think all of their scientific evidence is absolutely true, and we completely agree and concede legally. We can see that this person is innocent. It's damn hard for a judge to say no. So this is another sort of capability that CIUs and CRUs bring to collaborative work, is essentially a form of collaborative non-opposition, which a number of the IOs identified as a crucial component of why collaboration was such a valuable thing for their clients and for their overall commitment, organizational commitment. And now if we, Taylor, could go to our next slide. This one's a little bit more complicated, but I want to focus on the emerging theme of organizational constraints. And this is something that, if you look at that first bullet point, I sort of put up there as incomplete institutionalization. But I want to actually take a step back to sort of make sense a little bit of some of the constraints that are going on. A lot of the initial collaborative conviction integrity grants that we evaluated in this study were used to seed fund CIUs and CRUs. So this was a time in which there often was excitement and interest in prosecutorial offices in having a CRU or a CIU. And yet there wasn't what, so the late political scientist James Q. Wilson used to say, is there wasn't a lot of organizational slack, right? There weren't a lot of bodies who were, didn't have something to do. And so these grants initially provided a lot of seed funding to create that first designated person, that first designated investigator, to provide funding for that initial round of DNA testing in collaboration with an innocence organization. So that's a lot of what those initial grants provided. And some of that is essentially a form of organizational sort of workaround. And that's because there wasn't that organizational slack, so the grant provides an opportunity for that. But in some cases, even when the funding was just one of the barriers that organizations faced, it could oftentimes be coupled with other things. So if you look at this second quote around funding constraints, you notice that we see that theme of prosecutorial offices saying, I would almost say county funding is going to go towards the actual prosecution of cases, but I think the other way that my elected can probably justify that to the county is preventing crime, right? I don't prevent crime. I'm doing something on the other end. So my salary is pretty much all, at least at this point, my elected is willing to give. And so you see, this is an example of that incomplete institutionalization, right? We haven't seen a lot of these collaborative grants create, sort of ever greater expansion of these organizational units of CIUs and CRUs. And so we see sort of a continued co-production of innocence work within these collaborations, even in some cases after the grants have ended. But you can also see in this sort of second quote, this interesting challenge and opportunity that collaborations offer to work around other bureaucratic constraints that contribute to that incomplete institutionalization.
Hi.
So in the case of the second example, we see, yes, absolutely, I prefer to just have this money in-house, is what this respondent is saying. Realistically for me, though, it's much easier to operate by giving the funds to somebody who is else. If it's someone who will work with me and work the way I want to work, to allow me some direction in the way that the work is handled and completed and done. And just to put a finer point on this, we had organizations that really said, look, I just can't hire. It's even if we had the funds designated, the nature of how county hiring or city hiring works is just too difficult. And so there was some flex in having essentially an outside party to enable this shared work to take place. And then the final point I'll say about sort of this theme of incomplete institutionalization is this challenge of, the quality of collaboration really is only good as the quality of the collaborators, as well as the quality of the communication between collaborators. So we saw, a lot of folks who are the sort of most effective collaborations having a huge emphasis on communication and sort of agenda setting at the beginning, and then routine communication to enable getting over those inevitable bumps and some of these constraints, as well as different priorities in the collaboration. And the ones that struggled more really had not necessarily set as clear expectations at the beginning, and then also often struggled with communication in subsequent periods. So I'm going to pause here because this is essentially some of the emerging themes we've seen. There's going to be a lot more as we dig further into the sort of rich experiences that were shared with us. But we're really privileged now to hear from some actual collaborators rather than evaluators who are going to share with us their experience and also be, really the primary experts to answer your questions about what it means to collaborate. So with that, I'll pause and turn it back over to Kia and Taylor.
Thanks so much, Charles. I guess before we move on, though, we wanted to open it up and see if anyone had questions about the evaluation. about the process, or about our findings so far, and or about next steps. Okay, well, if not, we will move on. Let me identify our let's see, I see Robin. Let me spotlight. It's Lori. Oh, okay. And Tracy. Oh, is she unavailable?
I'm here.
Oh, okay. Oh, let's see. Great. Um, thanks so much. So we'll move on. And so you folks had a collaborative grant, and so for everyone, in talking to all of the collaborations, your collaboration of the Michigan Attorney General's Office and the Cooling Innocence Project, as we all know, exonerations aren't, the be all, but you did have 4, and that's great. And then, but also, in addition to that, you had some early challenges that I think our participants here would be able to relate to. You were able to overcome those challenges and develop a great working relationship, and so much so that you decided to sign on to apply for another grant so that you could keep working together for another 3 years. And I think that fact says a lot about your working relationship, and your ability to work together well, and that you feel like you can continue to do some good work together. But before we get into that, I wonder if Robin, you could tell us a bit about the grant project and how it was conceived.
Sure, thank you. I was hired in April of 2019. AG had just been elected, then in November, so she just started in January, and she wanted to start a conviction integrity unit. The point at which I was hired and the unit was announced, there were no other regional statewide units. I take it back. There was one other statewide regional unit that had been announced 2 weeks prior to ours, and that was in New Jersey. Other than that, there were less than 50 units nationwide, and they were all county-based. So I got hired out of private practice. I came to work at the AG's office, and probably one of the first days I was there, I got a call that Marla Mitchell-Sitchin, the director of the Cooling Innocence Project, wanted to come over and talk. Now, keep in mind, at this point, we had less than no staff. I had been hired. I didn't have a secretary. I didn't have an investigator. I didn't have any lawyers. I barely had an office, and I certainly didn't know what I was doing. So I welcomed any collaboration to talk with anybody about what the process might look like. I mean, we were below ground zero at this point. So Marla came over, and she and I and my supervisor at the time, the 3 of us sat in a room and just sort of talked. Again, we're talking April 2019. What Marla knew and what I didn't know was that there was a partnership grant that was available right then. But it had to be applied for, I think it was the 6th of May, which meant I had about 3 weeks from the time I started to get this grant application in if we wanted a partnership grant. So not only did I really not know what I was doing, I didn't know what a partnership grant was. I didn't even know what a grant was. I mean, obviously I knew in theory what a grant was, but I had no grant-based experience. We didn't have a grant writer in the office, but after, I don't know, maybe we talked for a couple hours about what we might be able to do for each other. I knew it was something that I wanted to do, because the idea was to work together to move this forward. The other difference that I had, and I don't know if this is different from other folks or not, I came from a specifically defense perspective. So I wasn't really, and maybe this was naive, but I really wasn't worried at that point about having trust with the innocence world. I was more worried about being trusted by the prosecutors in the state and in the counties. So I didn't know if it was going to be good or bad to collaborate with an innocence project, but I did know I would be comfortable moving forward with them on my side.
And so one interesting thing was that, so Lori, you initially were with the Innocence Project prior to the grant. And then by the time the grant got underway, you were now with the Attorney General's office. And so, you know, that was something that, you know, you were a known entity, but now you had a new hat. Is that right?
Yeah, and I think the hardest thing was kind of what Charles talked about, which is changing that mandate. Because not only, you know, at the defense end, you're really responsible for your client. That's it. And you're 100% advocating for that client. And so when you take that hat off and move to the other side of the V, you know, in addition to wanting to do the right thing for that defendant who's no longer your client per se, you now have the responsibility to local prosecutors, to local law enforcement, to victims, to, you know, Robin, my boss, to our boss, the Attorney General. And so it's adding an additional mandate that is much different from what I had when I was at Cooley. And, you know, for anyone who's in a CIU, we're already seen as internal affairs. Like, we are completely seen as defense attorneys trying to hide. And so not only was I, you know, in a CIU, which is AKA internal affairs, but then also I was from an innocence organization. So they're already thinking I'm just a defense attorney trying to hide. And then in addition to that, I was also at Cooley, who's our collaboration partner. And so I found it very difficult to separate from both ends, which was, you know, my office thinking I'm just an arm of Cooley, and, you know, just kind of siding with them, but then also Cooley thinking, no, I'm this prosecutor who's just trying to fight them. So to me, I was kind of torn in the middle at different times because, you know, just of my background and where I was seen. And I had personal relationships with the Cooley Innocence Project because I was there for so long. So it was definitely difficult changing my hats and trying to also try to express to the people around me, you know, why I have different hats and why I may be changing my tune on certain things because I had to.
Yeah, and I'm sure that, you know, with the increase of CIUs, we're seeing that a lot nationwide of innocence, people who previously worked at innocence projects now, you know, a CIU pops up and then they work for the CIU. So I guess before we turn it over to Tracy, if Robin and Lori could talk a little bit about some of the things that you did on the front end, you know, to as the project got started, or maybe even leading up to the project getting started, to create trust and to just get things underway.
Well, I think part of, especially with Lori coming over, the trust really, I thought, was there. I've always felt in working with Cooley, in working with Marla when she was director, and in working with Tracy now, I'm so happy Tracy's nodding her head, that it's really a very casual, professional, but comfortable relationship. And I think that our ability to communicate within our office and across lines has always been good. I think it was from the very beginning when we didn't know what we were doing, when we were unsure of what our roles was going to be. I know Lori and I worked a lot. Lori is way more organized than I am. I'll give her all the credit in the world for that, in setting up protocols and templates, in trying to best identify what we think our job is and what we think Cooley's job is. And when it became unclear to one side or the other, I know Tracy and I have talked on more than one occasion about, wait, we got to step back. Let's talk about what are we supposed to be doing in order to help one another. The way we worked things, because of Lori's knowledge at the front end, was we screened our own applications. We still do it this way. We screen our own applications as they come in. Anytime we see a case that is possibly a DNA or other forensic matter that we think Cooley probably has more, might have more knowledge or might be able to gather more information or clarify some of the allegations, we immediately send it over to Cooley. They then send a secondary application and develop a connection with the applicant. And then once they're able to gather more information, review it, come up with a decision or a recommendation, then we have our monthly meetings, Lori primarily, where we go over a handful of cases at a time. And let me just add one other thing, and then if Lori wants to add, one of the things we found is that Cooley was reaching out to local law enforcement to get police reports in order to make decisions about forensics, and they were getting back reports that were so redacted, they bordered on unusable. And so what we did is develop a common interest agreement that we use with individual Cooley cases so that we're able to obtain the unredacted reports and share them with Cooley in a limited capacity so that it makes their job helping us and helping these potential claimants actually be able to identify the information that we need. Lori, you want to add anything?
Yeah, so the very first thing I had to work through was ethical issues, because a lot of the clients at the Cooley Innocence Project were my former clients. I had retained them. So at the time, the office was very small. It was myself, another attorney, and I think an LLM fellow. So there was only 3 attorneys in the office and I don't know, probably 20, 25 litigation cases. So a lot of those were mine. So when I switched to this side, it was, okay, what are the rules? What are we comfortable with, not just in regards to ethical policies, but optics? We don't want local prosecutors thinking, oh, well, Lori was, that person's former attorney, and then all of a sudden, lo and behold, she's letting them out because now she's a CIU attorney. So it wasn't just the, straightforward ethical rules, it was also the optics. And one thing that Robin and I really stress is, how does what we do affect the innocence movement and conviction integrity units, and not trying to shine negative lights on that, because that's really important to both of us. So, again, not just ethics, but what are the optics? And so my first task was, which files do I have to pawn off on Robin, because I can't even touch them. And so that was one of my first things I had to do, as well as, if we're sharing these informations and we're sharing questionnaires and things like that, what about the defendant's rights and their rights to not hand anything over that, they thought was pertinent information with just their counsel. So there's a bunch of ethical issues that we kind of had to work through at the beginning, and that was one of the first steps we had to take.
Great, thank you. And now we'll bring Tracy and Ann into this. So Tracy, you had an interesting situation in that you came on, after the grant had already been, applied for and obtained, thereabouts. And so why don't you tell us sort of where things stood when you came on and how you, navigated this process.
Right. So yeah, it was very interesting. I came on sometime during 2020, in the middle of the pandemic, while we were all remote, et cetera. And as Lori and Robin mentioned, the collaborators in this instance knew each other to a certain extent. And I was truly coming from, like, we're based in Lansing. I was coming from Grand Rapids, right? Didn't know. So of course I was immediately excited and intrigued by the partnership. Marla had explained to me how she had worked with Lori and Robin to set it up, and even with all the ethical issues, it was just a wonderful thing that we had, kind of a person that we knew we could trust to move forward the innocence movement, like Lori stated, at the Attorney General's office. So we knew, and I knew Robin, from my past professional life as well. So coming in, I knew that they were people that I could kind of trust inherently with respect to the work, right? That we were on the same page, we had the same mission. So that was wonderful. What I didn't know as much about, right, was like Robin, like everything else, right? So while it was, of course, necessary to wall Lori off of all these cases, it was also a challenge for me because she was at the time, probably the most knowledgeable DNA attorney in our office. And all of a sudden we had these cases that she was heavily involved in and she was walled off in, and I was learning DNA as well as how, kind of how to run this office. And so, that was quite a challenge. And, more than once I was, yeah, it was a challenge. But I can't say enough about, Robin mentioned the relationship and the trust. And I know you mentioned at the top that exonerations aren't everything, but because we're a DNA and forensics clinic and don't typically kind of handle factual investigation, litigation, et cetera, we don't have the pace of our exonerations is not, like some of the other innocence organizations around in the area around the country. So we had maybe 5 or 6 AN exonerations before I came aboard. I've been here since 2020, and we've had 4, right, just on the AG side, right? So almost doubled. And so, Lori, you used to joke that maybe I was kind of a lucky charm, right? But I think it was the opposite. I think she was, right? She and Robin, and the collaboration, right, with the CIU. So it was exciting to come here at a time where I didn't have to kind of climb the mountains that Marla had, like kind of back in the day when we're begging courts to allow us to even test evidence, and the prosecutors fighting us even with respect to testing. That all of a sudden we had the resources to test. We had, partners who not only allowed us to test, were just as interested in us as getting to the truth. There were cases where we were like, should we test? And Lori's like, oh yeah, there's some stuff, let's go, right? Like, and so to me, that was just a great environment for me to learn the work. And like I said, it was just exciting to see the results of that, and our increased ability to help our clients. So, Anne, do you want to add to that?
I'll just say that it was to add to that. I had prior experience at the Cooley Innocence Project before I became the managing attorney, but I worked under a prior grant and worked with Lori. And one of the difficulties, it was very nice, but it's also, it was a learning curve to sometimes it seemed like we would forget that Lori didn't work at the Innocence Project anymore. And sometimes that was probably definitely unfair to Lori, where we kind of used her knowledge as a, we would pick her brain, and then it kind of clicked one day with all of us. We're like, Lori doesn't work here anymore. But it was, for the most part, it's been very, very positive in the fact that Lori, we had the prior relationship with Lori. We didn't have to start from scratch with developing that trust. Sometimes we probably put a little too much trust than we should have at times, and that was a big learning curve for our office. Not saying that we can't trust Lori. I think that came across wrong, but sometimes we had to really work on developing those boundaries and those lines.
Yeah, we had to remember, right, that we, as Lori said in her opening comments, when you're here, you are representing your client. Mm-hmm. And the AG's office has a broader, right, they have more stakeholders than we have. And so, in doing so and having this kind of casual but professional relationship, we have to remember, right, that at the end of the day, our obligation is to our client. And most of the time, right, those interests are aligned because of the similarity of mission and because of the people, right, involved. But, we are on technically, right, opposite sides of the V. And like I said, it's wonderful that those sides are working together, but we also have interests to represent. So Anne is right, that was a learning curve for us as well.
So now I think Taylor had some questions, but I guess before Taylor, you can ask, I'll share. We had a question in the chat about asking if Robin could share the sharing agreement that they developed with Cooley. And Robin, I'll remind you afterwards, and then I can send it out after the meeting.
Great. Okay. So I'm going to actually advance to our next slide because we have an interesting quote from Tracy that I wanted to kind of focus on. during our interview, you kind of focused on going from this sort of honeymoon phase where there's a lot of press releases and you're really excited about the collaboration to the sort of more realistic living together of the actual partnership. Tracy, if you could just kind of explain how you strengthened that relationship after kind of experiencing the honeymoon phase to creating this sort of living together to a point where you now have, you know, an extension for a grant for another 3 or so years.
Sure. Yeah. And so again, I think I have a particular perspective of this having come in from the relative outside, right? So I kind of almost liken it to my relationship with my spouse in the sense that we were friends for a long time, right? A long time before we got married. And so when we did, we were like, yeah, we've been friends for a long time. This is going to be great. And now we're going to go on vacation together. We're going to raise these kids. We're going to, oh, it's going to be fun all the time, right? And then we get back from the honeymoon. It's like, well, wait a minute. Like we actually have to kind of live in this house together. And what do you mean you don't want me to put my picture right there? Where am I supposed to put it? No, I like the dishes on this side, you know, et cetera, et cetera. You realize that there are some very practical things, right, that you have to work through in order to be successful long term and not just be happy in the short term, that once you get beyond the kind of feel good of all the positives of the collaboration. And so, you know, that's what I think about when I came in. You know, I came in kind of at the high of this honeymoon phase. And I remember just a couple of instances where we were, you know, kind of, because again, we used to all in some way, shape, or form work together, right? And when you have disagreements, when you work together, you kind of hash it out and then you go out to lunch, et cetera, et cetera. But when you have disagreements and now you're in separate offices, kind of what do you do with that, right? And how do you have disagreements and not take it personally, right? You know what I mean? Like when you have this person that you've been friends with and used to go to lunch with, you know, every Wednesday, and you know each other's kids and you went to each other's, you know, and all of a sudden, right, you're representing the interests of your respective office, and you're like, well, wait a minute, you know, and so that was a challenge for a minute in our office, you know, just with respect to not necessarily the systems themselves, because the things that we've implemented have been very helpful. The common interest agreement has just allowed us to share materials in a way that is so much more efficient for us, and we couldn't have done it that way without, you know, the trust that we have, drawing on, you know, working with the labs together, all of those things. Well, we've eventually, the monthly meetings that we implemented, I think have been incredibly helpful. But they didn't just pop up, right? Like they were a lot of work. It was, okay, why aren't we getting through these cases faster, right? What happens when the CIU wants to test in a case and we're like, well, we don't know if if that's an appropriate case for us. How do we, right? Do we test every time they want to? Do they have to accept every case we have? Like, how is this going to work, right? How do we, you know, how we meld that? How do we keep up with, right, the loads of cases that they got when they opened, and they get all these cases, and you know, many of them involve forensic, they send them to us. How do we hold ourselves accountable, right? So that when Lori or Robin calls us and say, hey, have you gotten to John Smith yet? We're like, John Smith, let's see, right? And when you're only talking about your office, right, that's one thing, but now you're accountable to a partner, right? And we can't just kind of get offended when they call us on that. We got to figure out, you know, how to make that happen. And so, again, I think it was somewhat particular to our group because of the personal relationship. And anybody who has personal relationships knows that sometimes it's harder, you know, to work through things with people you know well, right? You know, sometimes you get more benefit of doubt to a stranger, right, than you do to your loved ones. But I think it is just true across the board, like, you know, kind of the rules of engagement, right? And that's something that I think we maybe assumed, to Anne's point about when she says too much trust. I think that, you know, we assumed that the rules of engagement would be easy and free flowing because of, you know, maybe because of how well we knew each other. And we realized along the way that it was something that we had to be pretty intentional about. And I think we've done so somewhat successfully. I hope that Robin and Lori would agree with that, even though it was prickly for a minute.
No, I think it has. And I got to jump in just with one really quick story. And you guys will, Lori, Anne, and Tracy will remember our last exoneration. Our last exoneration was a DNA exoneration that moved really fast, but not as fast as some people wanted it to move. And at the very end, Tracy's laughing, at the very end, Marla and I were like, poor Lori, who was trying to stay on maternity leave, Marla and I were like snipping at each other and arguing about getting her client out on bond. And we were just very short fused with each other. to the point that when it was all done and over with, probably the next day, maybe 3 days later, I think all of us at 9 or 10 o'clock at night were calling each other to say, hey, I really appreciate you. I'm really sorry if I excuse my language, if I was shitty, if I was short, and if I was prickly, I didn't mean it. And I really appreciate the work you've done. But I found myself being insulted because Marla was questioning me about something that, as the claimant's lawyer, she should have been questioning me about, which goes to what Tracy said, because I see myself as friends with them in many ways. I was insulted by being questioned, which was really unfair on my point. But that's what happens, right? When your friends are on the other side sometimes.
Absolutely.
I get more insulted.
Yeah, and I think that's a great example, right? Because we got to the ultimate result, which was a just result finally, right, after decades in incarceration for this man. But like I said, we had to work through that. And very diplomatic in your description of the final moments.
When I was texting Lori about what is wrong with her. And I'll add on that note that all we need is for Lori to continue to get pregnant, because every time she's on maternity leave, we have this wonderful DNA releases. It's amazing.
All right, Lori, baby number 3, let's
go. One thing I wanted to jump in and offer is, you've mentioned before about how, the trust that you had in each other, and it seems like in knowing that you all had the same overall motivations in the work. And I wonder if you could talk a little bit. I still want to get to a final round of like do's and don'ts, but maybe before we do that, just offering sort of how much that trust sort of helped you get through all of the bumps like they you described most recently.
Well, I mean, I think that's the base of it all, that we all work well together and we're all moving on the same path, because in some sense we're true believers. I'm certainly not the true believer I was when I was strictly being a criminal defense attorney 20 years ago, but we all have a passion for the truth. We all truly want to find out what really happened. And so in that sense, we all recognize that no matter what each one of us says or does, even in those final moments, it's only because we're trying to work for the good of the system, and for the good of all. We all know that we can't make a mistake, whether you're representing your client or representing the state and the society in a larger sense. We all know we can't make a mistake. If we let out a guilty person, all of us, the dominoes are going to topple. And so I think that there's a level of respect for that as well that keeps us all going. It keeps that sort of mutual respect.
And I would step back and just say, for general people working with CIUs, because I've been on both sides of the V, it's really important when you're working with a CIU to be honest about your bad facts. And some of the bumps in our roads have been where maybe those bad facts weren't brought forward as, hey, this is really bad, we got to work through this. And then they kind of were found out later on, and it's a big problem. And, we have to get over those bad facts. And so my biggest recommendation from being on both sides, if you're working with the prosecutor's office, they're going to find out about your bad facts. And just like, you're told in court, be forthcoming with them. Let's talk about it. Let's figure out how we can get over them together. Because again, if you start breaking that trust and trying to hide bad facts to your prosecutors, they're not going to believe you when you talk about any other case. So my biggest recommendation in regards to trust is just be forthcoming with your bad facts.
I totally agree with what Lori's saying. The thing that I wanted to add on to Robin's is that I have heard through going to different, conferences with other innocence organizations that maybe not all conviction integrity units are set up to actually exonerate or find the truth. Sometimes they may or may not be there just for political show. And one of the things that is very helpful in our collaborations that we have with CIUs is that we can trust one another and know that it's a genuine, legit conviction integrity unit, and that the people involved actually want the truth to come out. So I think that back to that trust.
Yeah, and I don't have anything to add to that except to echo that. So even when we have a tough day or a tough conversation, or we're calling each other apologizing, we know, right, at the end of the day that we respect one another, and and we care about the work. And so yeah, that gets us through a lot.
All right. Well, Lori kind of started it off, but if we want to just go around quickly, kind of your biggest do and your biggest don't, if you are thinking about getting in a collaboration like this, or if you're even working with an office, maybe it's more of an informal partnership. So I guess we can start with maybe Anne, your top do and don't.
I'd say the top do is to be flexible. You may come up with all of these like policies and procedures, and as we have all discovered, that not every case is cookie cutter. There's got to be room for flexibility, where like we may have done something one way in one case, but that doesn't always work in every case. So being flexible really helps. As far as my don't, I'm gonna have to think about that and come back.
Okay, great. Robin?
I would say the top do, and it really mirrors a lot of what we've been talking about, is communicate. Just keep the lines open. Talk to each other about cases, about policies. And I can't stray very far from what Lori said. Don't hide the ball. Don't lie. Absolutely don't. If you're not sure, say you're not sure. If you don't know the answer, it's okay not to know the answer. But don't lie, because it's like you tell young lawyers all the time. The legal profession is really much smaller than you think. And the first time your reputation takes a hit, you're going to have difficulty the rest of your career coming back from it. That maybe holds more true in this very small community.
Definitely. And Tracy?
So yeah, I'm going to copycat a do and kind of piggyback off of what Robin said about communication. And the other side of the coin for me for don't is don't assume. So communicate and don't assume. And communicate about the big things and the small things. Certainly at the beginning, it could seem kind of like overkill or over communication. There is such thing as that. But I think as you're getting to know one another in these new capacities, right, communicating is incredibly important. Since we've started having monthly meetings, for example, I think that we kind of moved cases forward in a much more efficient way. And don't assume, right? So if you are, right, assume the best. Don't assume the worst. If you have an issue, bring it up, right? Bring it to the person. And it's fine to vent with come to IP and say, I can't believe the CIU was taking so long and they haven't lesson. What are they doing over whatever, right? But don't assume, right? Particularly since we talk about all this trust and how we know each other. But even if you don't know each other, communicate, right? Be clear about the process, right? If you have a question about something, ask, and hopefully you have a relationship where you'll get an honest answer, even if that answer is not one that you necessarily like, right? So don't assume things, and kind of be willing to accept the input and the reasoning from the other side.
And then quickly before we pass to Lori, we had a question from Lori Gibbons. For Tracy, is Cooley involved in every Michigan AG's conviction integrity investigation? And if not, what is Cooley's role if a defense attorney or another innocence organization brings a case to the AG's office?
So I'll let Robin, kind of answer this as well, but the short answer is no, we're not involved in all this. So that's a great question. we have a partnership with them where the cases that they refer to us for forensic evaluation, we partner with them on, and we will usually work with their DNA attorney, who historically has been Lori, and to shepherd the case through whatever testing we're going to do, et cetera, right? And then kind of hand it off to them for factual investigation if appropriate. And, I won't spend too much time talking about that process. But the AG's office gets inquiries from all kinds of folks, not just us. And so they've had exonerations that, that have nothing to do with us. And Rob and I will let you kind of speak to that.
Yeah, no, that's fairly accurate. I mean, we do get litigants that are represented by private counsel. There are times when we will suggest that private counsel consult with Cooley, especially if we want to bring it in under the grant. And then there are other cases. I think our second case, Corey McCall, was a case that came to us. He was unrepresented, but we wanted to do some DNA work. And one of the first things Lori taught me, which is so true, is before we're ever going to do DNA testing, we want to make sure that a claimant has a lawyer, because there's a downside, right? Once someone DNA tests, there was one of the quotes that Charles used early on about how surprised you were when you got the inculpatory information, right? We don't ever want to test somebody and then get back bad results that are going to be used against them forever and a day in the future. That person needs to know going in what the downsides are, and they need independent representation. So it's a long way of saying, if we have an unrepresented litigant and we're going to proceed with DNA testing, we in the past have looped in Cooley and asked them to meet with the claimant to determine whether they would represent them.
Absolutely. And Corey McCall is one of my favorite clients, because that's literally one of my first tasks when I came on as director. Was I got to go to the facility and let him know that the AGCIU was granted relief. I'll also point out that we Cooley have cases other than the AGCIU cases. So we also have a partnership with Wayne County here in Michigan, and we also have our non-referral cases that we've had that have been on our list for a long time. So we work with other folks as well. But I will say this has been just as far as results are concerned, the most fruitful partnership that we've had this.
Thank you. And then last but not least, Lori, your biggest do and your biggest don't before we
so biggest do, collaborate in whatever form that may be. Defense has access to obviously the claimant. They can tell a lot more about what actually happened back in the day, because there are times when I'm reading a police report and I'm like, please officer, ask them who was there. And they don't. And then we have to, find out by going through counsel. So just having defense there who has access to their client, they have access to previous defense files. They just have access to things that we don't have. So collab in some way, that's a big do. My biggest don't is kind of weird administration thing, because I've been on a grant where we are a sub-grantee at Cooley, and then here they're not actually officially a sub-grantee, they're just a partner. And I actually prefer the partner much better administratively, because we still work together, but our offices are separate. So we don't have to coordinate funding. We don't have to coordinate reporting. We can just do what's internal to us, which is a lot easier than collaborating with two separate offices. So still collaborate, but it doesn't mean that you have to have a sub-grantee on the other side of the V. It just means create some sort of partnership. And that's what we did through these grants.
Great.
Great. Well, thank you all so much. Thank you to Robin, Lori, Ann, and Tracy. Thanks everyone for joining. So my and Marissa's contact information is up. If anyone has another question, feel free to email either of us. We will send out those materials afterward, and stay tuned for our webinar next month. I'm not sure what the topic is yet, but I'm sure we'll be emailing that out a few weeks before. So thank you all so much again.